With only a few months to go before South Africa holds its 2024 national elections later this morning, the Constitutional Court is expected to hear applications submitted by the Independent Candidates Association of South Africa and the One SA movement about the constitutionality of the Electoral Amendment Act. Among its implications, the Act allows for the inclusion and nomination of independent candidates as contestants to elections in the National Assembly and provincial legislatures for the first time, and also a revised formula for the allocation of seats and their allocation in the event of vacated seats. Now, to talk more about a possible ConCourt outcome and implications for the 2024 elections, we are joined by Lawson Naidoo, who is the Executive Secretary for the Council of the Advancement of the South African Constitution. Lawson, thank you. Good to have you. Thanks for joining us.
Good morning, Leanne. Thank you very much.
All right, so one of the applicants, the Independent Candidates Association of South Africa, contends that the amendments of the Electoral Act do not level the playing field, as an independent must get more votes than a political party to gain a seat in the National Assembly. So that's just one of the issues at hand here. What is your view as CASAC?
Well, we've made it clear all through this parliamentary process since the New Nation Movement judgment in June 2022 that the process that was followed in Parliament was highly problematic. Firstly, it took 18 months from that judgment before the Minister of Home Affairs tabled the amendment bill in Parliament, time that we believe was wasted. He would argue that during that period, he established a ministerial advisory committee to advise him on electoral options. But at the end of the day, the minister ignored the advice from the majority of that panel and went with a minority view, which is highly problematic. And I see it, I think we see it in the concerns that have been raised by civil society organizations, as well as in this court case that has been long coming. And I think the issues that are being placed before the court today highlight some of the anomalies in choosing to simply tweak the current system to try and accommodate independent candidates, whereas the most realistic way of fairly accommodating independent candidates is through a constituency system, whether it be a single member or multi-member constituency as proposed in the Versailles-Slabbert report. And I think there was a belated acknowledgement by the minister and by Parliament that what is in this bill is not ideal, and therefore they've recommended the establishment of another panel to assist in determining electoral options. So those are the sort of the background to the process that's given rise to these legal challenges by the ICA and the One South Africa movement today. As you say, Leanne, they focus on on the proportionality of the outcome, with the ICA arguing that the split of seats should be not 200-200 as we've become accustomed to, 200 regional seats and 200 national seats, but that the split should be 350 regional seats, which would give independent candidates more of an opportunity to win seats. And then the One South Africa movement complained about the signature requirement, which is pegged at 15% of the quota to have won a seat in the respective region in the previous election, which in a provincial election could range between 4,000 and 9,000 votes, and for election to the National Assembly between 10,000 to 14,000 votes. And there's lots of argument in the court papers about international comparators, and what's appropriate and what's not. And the minister himself says, well, the line has to be drawn somewhere. Parliament has chosen to draw the line here, and it's not unreasonable. It may be a bit high, but it's not unreasonable. And then, as you say, there's a debate about what happens when an independent candidate vacates their seat through death or something like that. There's no other person that can take it, so there has to be a recalculation of the original result to determine who that seat then goes to. Yeah. So these are some of the issues that are being discussed today. I think ConCourt is in a very difficult position.
Indeed. Because
it could be argued that the Parliament has the right to make these policy decisions, and it may not be appropriate for the court to tell us what the electoral system should be, unless, of course, if the court decides that some of these issues that are being raised by the applicants actually do contravene constitutional provisions.
Yeah, and the IEC basically is warning that at this point, if there's the implications will delay the elections, and that's the reality. And as far as I understand, the IEC are not necessarily contesting all of this. They say that they need to get this decision made by the ConCourt so they can start preparing for next year's elections, which could very much so be in jeopardy with regard to what happens here. But let's talk about that. How could this jeopardize South Africa's elections going forward with regard to independent candidates?
Well, like I said earlier, Leanne, I think we've been chasing our tails ever since the New Nation judgment in June 2020, and the fact that both the Parliament and the Minister were somewhat slow in implementing or putting forward the amendments to the Act. So we're now left with the situation where elections need to be held next year. The IEC has filed in this court case a notice to abide. They've provided explanatory affidavits, but will abide by the outcome of the case, therefore they're not parties. But they are saying that they need a decision soon, and I think they would like a decision by sometime next month in September in order to plan properly for the elections next year. So there are time pressures here. Those, I think, are recognized in the pleadings by the parties. Both the OSA and the ICA have said that if the court finds in their favor, they should exercise their reading in provisions to amend the legislation as they propose, so that it doesn't have to go back to Parliament, because everyone is aware there isn't sufficient time for Parliament to do that. But the IEC needs finality, and we need to have these elections next year. We know from previous experience with the local government elections in 2021 under COVID that the court has said that they will not postpone elections. So as flawed as the system might be, we're going to have to live with it for next year, unfortunately.
Indeed. Whichever way it works out. And I mean, just the time frame we're looking at is that next year the elections should be held constitutionally between, I think, around about the 22nd of May and the 14th of August. So, you know, we're already under that year mark, and that's the reality. And there's a lot that needs to be done also for political parties and particularly for independent candidates, if this does in fact go ahead. So the court challenges centres on the Electoral Amendment Act signature requirement, which states that in the case of a party with no representation in the National Assembly or provincial legislature, the same signature requirements apply for an independent candidate. So candidates must gather 15% of the previous election's quota in supporter signatures for a seat in national or provincial legislatures. So my question is, what will guide the IEC from amending this requirement should the court rule in the favour of applicants?
Well, that's something that's set out in the legislation, so that's something that Parliament would have to amend. It's not within the scope of the IEC to do so. But what the applicants have asked the court is to provide a reading-in mechanism where the court substitutes what's in the Act for what is being proposed. And they're proposing that the threshold should be 1,000 signatures for independent candidates and unrepresented political parties. So if the court agrees with the applicants and they effect that reading in, that will be the basis for the election next year. But I think the important thing here is that everyone, the IEC, as well as political parties, need to have certainty, as well as independent candidates, of course, need to have certainty about how next year's elections are going to be run. We know that the election campaigns have started. Parties are starting to identify candidates for their lists. Independent candidates need to secure signatures and also start campaigning. So certainty is really required sooner rather than later.
It certainly is, and that's this is the reality. I mean, the challenges were made in an urgent court application by the Independent Candidates Association of South Africa and the One SA movement. What will the court consider in making a ruling? Obviously, this is a very urgent situation that we need, and we can hear why. But let's perhaps look at it from the court's perspective now.
Well, I think what I would say, Leanne, is that it's clear that this bill is flawed. It's flawed in many respects because the mechanism it's chosen to accommodate independent candidates, being a tweaking of the current system, is wholly inappropriate. And I think those the anomalies that have arisen as a result of that, that we need a constituency-based system in order to properly accommodate independent candidates, as well as to ensure greater accountability. But that's not possible for next year's election. So what the court's going to focus on today is to say, well, hear the arguments, look at the problems that are being identified, in the legislation. And the crisp question the court has to ask itself is, do these issues transgress fundamental constitutional provisions in terms of the right to vote, equality, the gender proportionality that's set out in the Constitution? And the court really has to focus on its constitutional responsibility. There are many arguments about what's the best electoral system, and if we look around the world, there are probably hundreds of electoral systems. So to say that this is another electoral system is not good enough. One has got to show that the system that the Amendment Act puts in place breaches fundamental constitutional principles, and that's where the court needs to focus its attention today.
Yeah. As the friend of the court, the Rivonia Circular said that the signature requirement sorry, I beg your pardon, I'm losing my train of thought. The signature requirement on unrepresented political parties and independent candidates has potential to harm the constitutional democracy and our multi-party. It also introduces unequal and uneven treatment between those parties already in the National Assembly or in the provincial legislatures. That's just to quote pretty much so what they were saying. Do you agree with this particular statement?
I think there's a lot to be said for what's in that statement because, as I've said, some of these provisions in the legislation don't make sense, and they're a product of the system that was chosen. The question that, like I say, that arises is, are these obligations onerous or are they unconstitutional? And I think everybody accepts that there has to be some eligibility criteria in order to manage elections properly. So there are deposit requirements, there are signature requirements everywhere. The question is, what is an appropriate situation for South Africa, given where we are as a society? Parliament says that this is rational. They've debated it in Parliament and they've reached this conclusion. The Rivonia Circle says that it's unfair, it's too onerous, and it treats political parties and independent candidates differently, certainly incumbent political parties. Yeah. The response to that, of course, is that parties that are already represented have demonstrated their electoral support. And the papers highlight the fact that in the last election, we have 48 political parties contesting elections, with only 14 of those parties securing seats in the National Assembly. So eligibility requirements are a mechanism to limit the number of participants, while still respecting the fundamental constitutional provision that we are a multi-party democracy. So the eligibility requirements must not be so severe that they undermine that fundamental constitutional provision. And again, that's one of the fundamental constitutional issues that the court will have to focus on today.
All right, then just let's wrap it up. And Lawson, I mean, a lot of people listening to this and perhaps thinking, okay, but what does that really mean for me? I mean, we sort of look at the country, we look at the way that it's being led. We are hoping that perhaps by the introduction of the independent candidates, that things will change, the people will have more of a voice. Let's perhaps end it there, introducing and bringing independent candidates into the electoral system, but the way that it is now being proposed. How is that going to help the country and South Africans in general?
Well, it gives meaning to the fundamental right to stand for public office in the Constitution, so independent candidates are eligible to contest national and provincial elections. But again, as has been pointed out in the papers in this ConCourt case, independent candidates can only win one seat. One person can only win one seat. So whilst there may be an addition of a few independent candidates after the elections next year in our national and provincial legislatures, it's unlikely to be a significant game changer because, and we cannot treat independent candidates either as a homogenous group. They have different interests, different values, different principles, different ideologies. And I think the danger is to treat independent candidates as one group of people with the same interests. I think that's far from the truth. So what we do know is that independent candidates will and must be able to contest elections next year. And we also know, Leanne, that these are highly contested elections, with the predictions that the ANC is going to fall below 50% of the vote next year. All sorts of discussions about coalitions are happening, which so far have not incorporated or looked at the possibility of independent candidates holding the balance of power in some way if the final call is very close.